Well, hello, everybody, and welcome back to your favorite show on the internet, Raw Law Unfiltered. Looks like we have a jury
The
question.
evidence and our diligent consideration of all disputed
As
evidence, we have
my
been unable
guest
to
is
reach a
still getting
unanimous
ready.
verdict, signed by the foreperson.
What was the question?
So I
Sorry.
want to hear diligent consideration of all disputed evidence. The evidence form you jury. Dear Judge Canoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, signed by the foreperson. So I want to hear from counsel.
Jury.
Your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise.
There's got to be a holdout.
Persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock, and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
When jurors cannot agree on a verdict and report this to the judge may issue further instruction to them to encourage those in the minority to reconsider their position. These instructions are known as an Allen charge, or more casually, as a dynamite charge. The Allen charge is named for the United States Supreme Court case Allen versus United States from 1896, in which the court approved such instructions in federal cases. Wow, you guys. Absolutely wow. Absolutely wow.
Court, please. Jurors entering.
Do we know the split?
Court back in session. You may be seated.
Because if it's like 11-1 or 10-2.
Right. So, jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed
Disputed
by your
evidence.
foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right.
Ask the
So I'm sending you
split.
back up.
How are they split?
All rise for the
For the
court,
love of
please.
God, Judge Beck, do your job.
Jurors, follow me, please.
Oh my God. You don't just blanketly Allen charge a jury. Ask them, are you 11-1? Are you 10-2? Are you 6-6? That is when you decide whether or not to Allen charge someone. You don't just send them back willy-nilly, for fuck's sake, man. Do your job. Oh my God, man.
All right, so the note has been marked for identification, and we'll see you all either at 3:30 or when you get a phone call.
Court, all rise.
Triple V. Thank
You are muted.
Oh, God damn it. I'm sorry, you guys. I'm livid. I'm absolutely livid. This judge is just incompetent, just completely incompetent. The whole point of an Allen charge, before you Allen charge a jury, which is, like I said, that is when you issue them a specific instruction to encourage those in the minority to reconsider their position. You don't just willy-nilly send them back. There's a specific way of doing it. There's a rule of law from 100. You like to quote John Adams so freaking much. This law has been around for 130 years, woman. 130. All right, I'm calm. No, it's not reversible error. All right, folks. Let's get back to our main event for today. We have a guest. Hopefully her technology works. Hopefully her technology works. I guess I was gonna check behind the scenes, but unfortunately I can't do that right now because we're already live because we saw that the jury had a question. I present to you Lindsay. Hi, Lindsay.
Hi, how are you, Larry?
You can
Good
hear
to
me.
talk to you. Yeah, I can hear you.
Oh,
Yeah, amazing, right?
fantastic. Okay,
Imagine
technology's
that.
working. All right, awesome. How are you?
Good. It's been a minute since we've spoke, hasn't it?
It has been. I think
It has been.
last year or something around this time.
Yeah, it's been about a year, I think. Because I was thinking last night, did we talk when you were in Israel? And I think we were just texting because.
Israel. Well, you probably were checking in on me.
Oh, yeah, absolutely, of course. Yeah. So, yeah, and then
we met
that was
each other.
so
You reached out to me back in the Johnny Depp trial, I believe, is when
I
you
think, yeah.
initially reached out to me.
I don't remember why. And then remember, I don't know how many followers you had then. And I, like, last night I looked, I'm like, 450,000 subscribers. What happened? You blew up. Wow, I just hadn't checked the numbers lately, but congratulations on that. That's amazing. I mean, it's no
Thank you.
surprise, of course, but you know, it's really awesome. I'm glad. I'm glad people have found you and like listening to you because as I do. So yeah,
I really appreciate you. Thank you so much.
oh, of course, you too. So yeah, so I don't know. You can start. This is your show, so you lead, and I'll just
Okay, so
follow.
I'm gonna lead. All right, I'll take the lead. So tell us
Yeah.
first of all, because everybody obviously has been asking. You are not one of the alternates
Sorry,
from the
guys.
Karen Reed case. You don't live in Massachusetts.
No,
You
no
are not.
accent.
There's
Yeah.
no relation to Karen Reed, but you have actually served on a jury before. And I'm not saying served as in like you've been on a panel and let go. You were selected to listen
Yeah.
to the evidence.
Yes, and it lasted 3 weeks.
So
And
okay, so let's begin at the beginning. So where was this, first of all?
it was in Pierce County, Washington,
Okay.
and so it's just further south of Seattle. So I live in a small town called Gig Harbor, and but still Pierce County, and you have to cross a bridge to get there. So I always say you have to cross the moat to get to that side of town, and then I mean there's areas of Tacoma that are great, but in Tacoma, Washington, actually, and yeah, so I don't know if I know you have listeners all over the world now, which is great and amazing. So I don't know if they understand the process, if we want to go over that together, or maybe people don't understand how that works, or do we want
Go
to
ahead, please. Enlighten
I
us.
was just
Tell
like,
us.
well, and you please jump in because of course I know there's areas where I was just a juror and had no idea how they came to this, but in the US, if you're a citizen, your civic duty is to be on a jury, if you're selected for a jury, to show up. And many times in our county, at least, you'll get a jury summons and you have to call in on the Sunday to see if you have to go to the courthouse. And that's happened to me many times in the past, and I haven't had to go in. But this time I call and say, like, you were required to report to the courthouse. And I go into this huge room, and I think it was 300 people that were called in. So, and
That's a lot. That's a big county.
Yeah, it was a lot. But for some reason, I have to tell you, I just knew I was getting selected. You know, you just get that feeling. I've never won anything big, but if I do run a small raffle, sometimes I've had that feeling before. I'm going to win. And I was like texting people, I'm for sure getting selected. It's like I just knew. And then but from there you start with 300, and then you go in and they give you forms, you fill them out, take them back, they give you a number, and then you just kind of sit and wait for further instruction. So you get called, and they got one group of 30 that were called, and shortly after that there was another group of 30, and from there we went to basically a courtroom, and we were sitting in where the spectators would be, anybody who's in this, like as you were in the Johnny Depp trial or Karen Reed, in that area where we're sitting, the 30 of us who were selected. And but in front of us, there was a judge in the middle, and then there was the plaintiff. And this was a civil trial, so it was a little different. But it was a person suing a person for a substantial amount of money that would have been, by my estimation, significant and life-changing on either side. And so despite it not being a criminal case, it was a very serious matter, and because the amount of money. And but basically what happens is you're sitting there and they call your number and you stand up, and in our county at least, you say your name, which to me was shocking. I thought it was just going to be referred to as a number, but they knew my name, they knew what I did for a living, they asked all these questions. And I went over, I said, I got my CPA license in 2001, 2001. And they asked me about kids, and basically what they asked everyone else, and like, can you serve on a jury? And there are people there, one had just had back surgery, so that wasn't going to be good to sit for that long. They told us the trial was only going to be a week. And so I thought, and I know probably not unlike you, Larry, and a lot of people, your listeners, that if you go away, your work doesn't get done for you. In my job and in accounting, my work just kind of waits for me. So, but I thought, you know what, it's only gonna be a week, I can do it. I've done it for vacations before, and I can figure out stuff with the kids. My kids were 13 and 16 at the time, or 15. Yeah, he was almost 16. And so you know, thinking I can make it work. And so I just thought, okay, I'm just gonna do this specific duty and to be honest. And but they asked each people, we went on, they dismissed quite a few. And then I think we had a break and then came back and they said, if we read your number, you've been called and the rest of you can be excused. And of course my number was read. So and in that, so maybe they went to lunch and then we came back and then they selected us. And from there, it was more just kind of a formalization of like, okay, here's just like, this is the juror room where you're supposed to report to. So you have to report to that juror room every day at 9, or it was either 8 or 9 o'clock. And so for this trial, even though like the court will start late, you have to know those jurors are just waiting in the room together.
Right.
Which is, and it's really odd to be in a room of 14 people. For me, it was a room that was smaller than my smallest bedroom in my house, full of 14 people. So you're very in this tight area. You have this conference table, a little coffee area, and then the weird bathrooms up front with hollow doors, which were awkward. It's like, oh God. But by the third, I ended up being the third week, no one cared. But and you can't leave. You're in there, you report, you have to be there. It doesn't matter what's going on in the courtroom. You're just waiting for them. And but so you know, they showed us the courtroom, talked about parking on it, and then the next day we're reporting for jury duty, as it were. And so reported, and I took it very seriously, of course. And I will say it's really odd because you think about it, like every time the court dismisses the jury, they go back to that little room and they're sitting with people, and the only thing they have in common at this point is this case, but they can't talk about the case. They can't even utter like, wow, that was intense. You can't even say anything like that. So they can't mention what's going on right in front of you and the one thing you have in common. So for us, it was 3 weeks. So you really kind of get to know each other because you have to have
you're trapped in a room, yeah.
Right, and you're getting dismissed all the time. Like objections to evidence that could be submitted or not submitted, as you know. And so you're going there. Yeah, right, exactly. And I want to reiterate, like, if you guys think you're frustrated, the jurors are just as frustrated. They can't leave. They can't go talk to anybody about this. They have to be quiet. They have to go to the juror room. They don't know anybody and pretend and have a conversation and then get to know people. But it's a little bit, that was kind of shocking to me. I knew that you could discuss it to Deliberation, but I don't know. I realized how intense that would be to not be able to speak about it with my fellow jurors of what just happened in the courtroom. And so
right, because you take your oath seriously because you're not allowed to deliberate until you're actually in that room. That the judge instructs you, do not make up your mind without hearing all the evidence. You're not allowed to make a decision. You're not allowed to discuss this case amongst yourselves. And how do you treat that oath at the time as a juror?
You just don't. You just you just do it. You figure out a way to do it.
You follow the judge's instruction.
Yeah, absolutely. Yeah. Because we're there and we're like, you know, I kind of resent it when people take shots at jurors because these people are taking time out of their normal daily lives. Maybe they're like me, my work is just piling up and I have kids and, you know, being a single mom and it was difficult to manage that. So I wasn't going to mess around. Like, I'm taking this seriously. And of course I would. And I think everyone on the jury that I was on took it seriously. I think some people paid more attention than others. You know, just, you know, compared to the amount of notes that I took that maybe others didn't. But I'm an accountant. I take notes. You know, I'm detailed. I'm analytical. So there's that. That doesn't mean they weren't paying attention or anything. And one difference I noticed in this, and maybe you can speak to this, Larry. In my trial, before a witness was dismissed from the witness stand, we were allowed to ask that witness questions.
Oh, yes. Okay. So some jurisdictions allow that. Some jurisdictions have prosecution questions, then defense questions, sometimes, very rarely, a judge question, and even more rarely, a jury.
Oh, shoot. You just froze up on me. Is that you or me?
Did my camera just crap out for a second?
Yeah, I think so. Yeah, it's still.
Back.
Okay.
If the jury has a question, sometimes they get a chance to ask a question as well. Now, that is not in every jurisdiction, but some jurisdictions do allow that. So in yours, you were allowed to ask questions of the witness.
Yeah, it was, and for me,
How did you like that?
fantastic, right? Like,
Why?
I didn't
Why is that fantastic?
Well, in some areas, like I caught the plaintiff because of my knowledge of accounting, or I was helping a lot with tech at my company at the time, and so there were some things that just couldn't happen in the world. Like he made the comment, "Oh, what do? I reconcile accounts payable to accounts receivable." That's not even a thing. Nobody. That's not even how you do accounting. It's just not. You don't reconcile accounts receivable to accounts payable. So this guy, and he knew my background, so I just think he was arrogant and could just snowball, like, and just talk over me, and I'm just like, okay. So like one of my juror questions was, kind of being a smart aleck, was, how exactly do you reconcile accounts payable to accounts receivable? I don't understand. And that question did not get admitted, because obviously I was calling him out, and basically I kind of felt like, it just is with an attorney, you're asking a question with a purpose, right? You kind of already know the answer, but you just want confirmation or to highlight it.
Yeah.
And that happened on several, and and like there was one time he said he was at the office, but yeah, his email was going through Exchange, and this is that time. So I don't know when all this took place. I think it was more like 2015, and this is 2018 when I was singing at the in the juror box. And so so it'd been a while, but I knew that you're not going to be on Microsoft Exchange if you're VPN'd into your computer. You're going to be on Outlook. It didn't make sense. Or if you're VPNing in, or if you're at the office, you're going to you obviously check it from any computer with Microsoft Exchange, but you use Outlook at the time, especially. I know things have changed now. I'm not as involved in IT anymore, but at that time I'm like, oh, really? Well, why? So that was one of my questions. Really? Why were you on Exchange when you were at the office instead of using Outlook? If you have a Windows-based system for your office, usually when you're in the office, you're on Outlook. So
you got a chance to do your own mini cross-examination.
I did, and I don't know if the defensive response team really had an idea of really what I was really proving, because I didn't have a chance to explain why I was asking it. So I could only ask the question. And I was like, kind of almost giving the defense team a hint, like, hey, look at this. And I don't know if they picked up on the significance of it, or could connect the dots. But, and maybe, I couldn't at the time. Yeah, but by the time I think by the third day, everyone knew the questions were for me, because most people had one or two questions. I usually have a stack and questions for most witnesses, and and on both sides, I was trying to, even with the misquote of accounting or whatever, I was still trying to be unbiased and give his plaintiff a chance. But things just kept happening. So it was it's hard to not kind of get biased when the person will start and you catch them lying. It's really hard to going forward to keep, okay, what's the overwhelming evidence showing? So, and another thing too, which it was funny to me, because when he first got on the witness stand, his attorney asked him, okay, what was your job title? What did you do? And they asked, are you an accountant? And he said, oh God, no. And I just laughed it off, because people ask me, and I'm like, oh, God, I wish I wasn't. I need to change careers. So it didn't offend me, but and that I'll bring up that there's a point to that, which I'll bring up later. But the whole process, it was really went 3 times as long, and I felt like it was because they weren't as prepared to go in with what they're submitting as evidence, or what they were arguing about what was allowed to be submitted and what wasn't, and that type of thing a lot. And I felt like this has been done after we left, and not wasting everybody's time. We're just sitting here. But as you know, I think it just comes up as it does, and then you have that disagreement. So you could probably speak to that. I don't know how often that happens with you, but it happened a lot with us.
Okay, so all right. So after 3 weeks of testimony that you're listening to various witnesses, by the way, was this a criminal case or a civil case? You said case. Plaintiff, so it was civil. And what was the? Sorry.
It was the respondent. It was a person. It was a civil trial, and it was, in my opinion, kind of like the Karen Reed. It shouldn't even gone to trial, because the plaintiff was trying to sue somebody personally for wrongful termination. And he like he was
Oh.
a shareholder at the time. He didn't even do any of the daily management. It's like, it's kind of like somebody buying Tesla stock and they getting personally sued for what's going on. If something happens at Tesla, and
Okay.
you know,
So, all right. So hold on. So let's get the basic facts. So someone is suing for wrongful termination, and they're also a shareholder of the company.
no, the person getting sued was a shareholder. Well, I'm sorry, I should step correct.
Wait,
This
the person
guy,
getting sued was a shareholder?
yeah,
It's like I own a share of Tesla stock,
and
and
it's
this person it has been fired from Tesla, and now they're suing me for
personally
wrongful
because
termination.
what happened is the company went bankrupt and all the management
Oh,
went bankrupt too. So he's
okay,
kind of
that's
like a
big.
wild
That's
card.
important. That's a very important fact.
Yeah,
So they're
yeah,
suing the people who have the money, basically, to be able to pay
absolutely.
for.
But that's not. There was no reason to break that corporate shield at the
But when
time.
you got a desire for getting compensation, you go to any and every available avenue. But anyway, I digress. So
You
so
probably
tell
should.
us now what we're all here for, right? Because here we are on hour 19 of the Karen Reed trial. No, the
Yes.
deliberations, hour
Much
19 of
longer than mine. Yeah. Like you
Karen
mentioned
Reed.
last night, it started in April,
Hold on, let
right?
me finish the sentence.
Oh, sorry, I'm sorry.
Let me finish the sentence, Lindsay.
I'm sorry.
Bring it down a notch. You're at about a 7. I need you at about a 3 right now.
Okay,
Okay?
I can do
All right.
that.
Awesome. All right, you're good. So we are at hour 17 of the Karen Reed or 19. Now I lost track. Whatever it is. We are on day 4 of the Karen Reed deliberations. The jury has been going back and forth. We have actually just received word about 15 minutes ago, for those of you maybe just joining us, that the jury is deadlocked. They are unable to reach a decision despite their best efforts, according to the jury. They sent a question in. It wasn't so much a question as it was a statement, because I was like, a question on day 4 is really rare, because if they had questions, they would have come on day 2, day 3, not day 4. And so we are all expecting a verdict today, because today is Friday. And
Right.
here we are. They're starting up their deliberations early today. We've also heard, by the way, that at least one reporter reported, who was standing right outside the courthouse doors as the jury was filing out of the courthouse yesterday. There were about 11 somber faces, and one man was smiling. Now, it doesn't seem like a whole lot of information, and it's really not, but we can deduce a lot of information from that, because it seems like it is very possible that one person is
the
a holdout, is the holdout. They're the ones who are like, yep, I'm in control of the situation. Everyone's like, oh my God, will they please change their mind? And no matter how much they're trying to convince, to sway, to influence, to discuss, to dissect, to
Right.
deliberate, this person is like, nope, 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 nope.
Right.
And that can be very, very frustrating, especially if, let's say, what if they are split 11-1? The fact that
Right.
Auntie Bev didn't even ask that, I am shocked.
Right? Yeah.
I am completely shocked. Hold on.
sorry.
She should have asked, are you guys 6-6? Are you 7-5? Are you 10-2? Are you 11-1? Because if they're 11-1, she can give a very specific instruction pursuant to Allen versus United States, an 1896 case from the United States, which I've already said. When jurors cannot agree on a verdict and report this to a judge, the judge may issue further instruction. It's called an Allen charge or a dynamite charge. To encourage those in the minority. See, she's talking directly. She shouldn't be talking to the entire panel.
Right.
Like, oh, please continue to deliberate like she did. No, she needs to find out, okay, so what's your split? 11-1? Okay. Or 10-2? Okay. So those of you in the minority, do you mind at least trying to reconsider your position? It seems like you are outnumbered. And what if they are 11-1? What if there's one person holding this entire jury in prison? Everybody wants to go home. Everybody agrees except for one person who may have been bought and paid for. Maybe that's the former police officer,
Right?
some of us
Yeah.
suspect. Maybe whatever. These instructions are known as an Allen charge, or more casually, dynamite charge.
Right.
And it's United States Supreme Court case from 1896 called Allen versus United States, which this instruction was approved in federal cases. Also, somebody has sent me, and I can share this with you all. Somebody has sent me this.
I have to get my glasses on.
When jurors cannot agree, she can instruct them as follows. Our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 6, in this case 12, minds, because 6 is for a misdemeanor court, 12 is for a circuit court case, in a felony charge like this one, 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinion. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. There is no reason to suppose that the case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all of this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. Maybe that's why she doesn't want to read it, because this instruction benefits Karen Reed.
Right?
In conferring together, you ought to give proper respect. This is from the Massachusetts Handbook, by the way. This is literally from massachusetts.gov. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. When there is disagreement, those jurors who are for acquittal should consider whether a doubt in their minds is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought to seriously ask themselves whether they may not reasonably doubt the correctness of their judgment, if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you now to return to your deliberations with these thoughts in mind. Now, the model instructions above and the alternate instructions below that we'll read in a second are adapted from the 2 alternative models set out, and this is what Yannetti was referencing, I believe. Commonwealth versus Rodriguez, 1973, Massachusetts. You know that's how you know. It's a Massachusetts case. The first is an amended version of a traditional charge developed in Commonwealth versus Toohey in 1851. So this is the 173-year-old case. The second, a model charge recommended by the American Bar Association. Judges have been urged not to stray from the language in the recommended model instructions. That was in 1997, which Bev just literally did. So somebody was asking, like, is it reversible error? I mean, probably not. If they convict, maybe it's reversible error. If they acquit, definitely not reversible error. There's nothing to reverse. But if they hang, I mean, again, what's reversible error? We remember, ladies and gentlemen, sorry, my brain just froze for a second. Lindsay, bring it down. Remember, when short of a guilty verdict, everything is a win for the defense. A hung jury, a not guilty, everything is a win. Everything that's not guilty is a win for the defense, period, the end. There is no ends, ifs, or buts about it. It is appropriate for the judge to give such a charge when the jury is deadlocked, which is what happened here. But because it has a certain stink to it, it should not be given prematurely. Any digression from the recommended language is discouraged. And I think this was not premature at all. This is day 4. They've clearly sent a note saying they can't decide. I think it was not premature. It was definitely time to be admonished. As to when such a charge is appropriate, see jury trial manual for criminal offenses, tried in the district court, subject to there's no per se rule that giving such a charge more than once is inherently coercive. So you can give it more than once. It has been given more than once, at least in 1982. There's a Massachusetts case, Court of Appeals case that has said so. Now, the alternate instruction. This what Judge Bev could have done in the alternative, again, which she did not do. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree to that verdict. Your verdict must therefore be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violating your individual judgment and conscience. Each of you must decide the case for yourself, but you should do so only after considering the evidence impartially with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. You are not partisans for one side or the other. You are judges, the judges of the facts. Your sole interest, I love that, you're judges of the facts. Because Beverly Cannoni is a judge of the law, you are judges of the facts. Your sole interest, they're the finders of fact. Your sole interest is to ascertain the truth from the evidence in the case. I would ask you now to return to your deliberations with these thoughts in mind. And there are a couple of notes here. I don't know. We're not going to read them. You're more than welcome. I tweeted it out, so if you want to go to my Twitter, there's a link to this article, to this instruction from the Massachusetts. I'm telling you, it's in Massachusetts.gov. It's not just some random legal scholar who has made a determination at some point or another. This is an actual government website. Okay. All right. So with all of this in mind, Lindsay, I want to get back to you. And I thank you so much for sitting here and waiting patiently. Okay, so in this civil case that lasted for 3 weeks, that, let's just put everything out. You all have just received the jury instructions. You have just listened to closing arguments from both the plaintiff and the defense. And we say plaintiff and not Commonwealth or state because it's a civil case, not a criminal case. And now you are sent back to the jury deliberation room. What happened in your
the
case?
first thing we had to do was to select a foreperson. And after I don't know her last name. I know that's disrespectful, but Beverly, we all call her now. But she selected a foreperson, and in my opinion, so we selected our own. It happened. They picked me,
Which is much more common, by the way.
Well, and I think that that's more appropriate because you spent intimate time with these people. You know who can lead, who's good at talking to people or not being intimidating, and is good at listening and kind of giving feedback and not gonna be a bully or roll their eyes at somebody else's opinion. By then they had always referred to me as the mom of the group, and I think that's probably why I was elected for. Everyone just decided it was me, and I just said, oh, fine, and that was okay with me. But
Were there 6 of you or 12 of you?
There was 12 of us, but we had to get to a 10-12 split. So when we got to 10, we were right. But I would
right, because it's a civil case. So in criminal cases, the decisions have to be unanimous. In civil cases, as long as there's a majority, meaning it's called super majority. So 10 of you.
Right. Now I remember
Yes.
that. Yeah. And so as soon as we got there, but you have to have a person who knows how to really talk to a person and not be condescending and respect their views and not. I like I said, make that person feel dumb or bullied. I mean, I will tell you, for me, there was some holdouts that didn't. I just well, what are your arguments for for the plaintiff? Because most of us were in favor of actually the respondent. And let me say first, the main reason for coming on here is to tell you that my trial is 3 weeks, or just over, and then we went to deliberations on a Wednesday afternoon as well. And we did not give a verdict until Monday morning. And this is a civil trial, and it was only 3 weeks long. So that's why I really wanted to first put your.
So 4 days. You deliberated for 4 days on a 3-week trial in the civil arena.
Yeah, because
Wow.
there was a lot of misunderstandings, and I don't want to sound discriminatory or anything, but it's just these people were very smart, but some people that were in our jury English wasn't their first language, although they spoke very good English. So when reading a contract, and we have like they had all over the world, and they'd come from like Eastern Europe, one was from Africa, and so it was all over the board. And they'd come over somewhere later in life, and they didn't maybe have the formal trading and writing skills. So when they were looking at this contract, they didn't understand really. I had to like step back and figure out, well, why are we disagreeing here? Like, because we both reasonable people. I saw what you saw. What are you saying that's leading you to be in favor of the plaintiff? And it came down to like, oh, like, well, this comma, like, or it says here that he is responsible. And I was like, no, that there's a comma there, and it would have to be if this and this happens, then he will be acting CEO of the company. But that didn't happen. And I said, so like that's qualifying the previous part of the sentence. And then the person was like, oh, okay. It was just a misunderstanding of the English language. And I had, including some of the alternatives, there was 4 people where they weren't born here. So sometimes it's just something simple as that. So you really have to have a person who's going to take the time to go through like, where are we disagreeing without being condescending, and being respectful. Like, okay, let's go through it. So I feel like with Bev picking a juror, she doesn't know the person who can do that. And
somebody
really
said, Neon Skyven is saying, what if the foreman or the foreperson is the holdout who was appointed by the judge? That would be horrific if they intentionally selected the one that they thought was going to be the most favorable one for the prosecution. And now that person is leading the entire discussion, and they're like, I think we should all vote guilty. And everybody's looking at them like, wait, what?
I had the same thought. Yeah, you're right. And that's exactly what I was thinking too. I don't know why I got the feeling it was a foreman, but I did. I really, so far. And if they can't lead, that's why I think the jurors should elect their foreman.
I agree. I've never, I shouldn't say never. I've almost never, because I think maybe Chad can help us out with this. Chad, in South Carolina, during the trial of Alec Murdaugh, didn't the judge pick a foreperson as well? I'm like 99.9% certain that the judge in the Alex Murdaugh murder case picked the foreperson. Let us know in the comments. I'm like 99% certain. But anyway, please continue.
Oh, I was just saying that I just think that give the respect to the jurors that they were much in a small room together for much longer than I was, and they definitely know each other pretty well at this point. They know people's personalities. They can elect their own foreman.
Chad is saying yes. Chad is confirming. So, okay, so my suspicion was right. My memory is not failing me. The judge in South, so maybe it's something to do with that coast. I don't know. Maybe it's the East Coast. So Murdaugh, the judge selected the foreperson. In Karen Reed, the judge selected the foreperson. I've never seen that in Kentucky. Literally, one of the first instructions when you go back to deliberate, your job is to select one of you as foreperson. It's in our jury instructions.
Yeah, that's the first thing you do. Yeah,
and we're considered to be one of the most corrupt states in the union, and even we have that out for the jury to be able to select
the most corrupt. That's funny.
Well, yeah, Kentucky is definitely not up there with the cleanest states. I will say that. It's just a fact, and
Yeah, I just but
Lucky says they're from your. By the way, in the comments, let us know if in your jurisdiction, if you've been on a jury, if you know, if you've been prosecuted or if you've sued somebody, whatever. You were probably privy to the process. You don't have to reveal the details. I'm not asking to reveal the details, but tell us if you've ever seen, other than in South Carolina and Boston, Massachusetts. I'm wondering if Boston. I meant Massachusetts. If in Massachusetts, other than Massachusetts or South Carolina, if there's anywhere else where jurors are selected by the judge.
And is it a rule, or do they have the option, or is it just the judge gets to decide? I wonder if it's standard procedure. I was wondering.
No, it's not standard procedure.
Okay. So like Beverly had the option to allow them to select a juror, or the foreman. You think
Georgia picks their own? People are saying Ohio picks the jury is picked by the jury. Kansas jury selects the foreperson. So there we go. We got 3 already. California jury selects the foreperson. Kentucky, I can tell you, selects the foreperson. I think Florida selects the foreperson. We've seen that already in like Darrell Brooks and a couple other cases that have already happened. Indiana picks their own person. Kansas, you pick your own. So it seems like Massachusetts and South Carolina are in a minority. Texas, you pick your own. Illinois, you pick your own. UK, even they pick their own. Massachusetts doesn't. We already know that. Alabama, the foreperson is chosen by his fellow jurors. Idaho, jury selects. Okay, so definitely, Massachusetts is in the minority, and they should all pick their own. Tom, I agree with you,
Yeah.
100%.
Especially in such a long trial where they do know each other so well at this point. They know who's going to be good at being able to get information and talk to people.
In
And not-
Colorado, jury picks their own. Mad scientist. Oh my god. Arkansas, that you pick your own. Oregon, you pick your own. And you're from Washington, right? You picked your own.
Mhm.
So
Mhm.
already, I think we covered almost 20 states. It feels like,
Right.
and we're already almost half. North Carolina, you pick your own. Wow, that's interesting. North and South Carolina have different rules. Anyway, sorry. Okay, this is
So
crazy.
it would be a state law then. It would be state legislation.
It's
then,
state
and
by
not-
state, obviously. Yeah, it's state by
Yeah,
state.
and not by county though. If you're in a
No. I don't think so. That would be creating too much chaos.
got it. Yeah. Okay. Understand.
In Maine, the jury picks their own. So I think we got enough answers. Thank you all so much, Chad. You're very, very helpful. Truly,
Yeah.
I appreciate all your input.
I would strongly recommend it that the jurors pick their own. I just
So Lindsay,
and I-
let's get back to you. So you picked your foreperson. You were selected as foreperson. What's the first thing you did?
we took an anonymous vote on where we
You
were.
started with a vote.
Yep, to see where we were.
Anonymously, like 12 Angry Men, Henry Fonda style.
Yes, definitely. But put it. I think we put it, in a folded in a piece of paper and put it in the hat, somebody's hat, I think. And then I think we were 6 to 10 or around there, and it was
6 to
anonymous.
10 Wait, there were 16 of you deliberating?
No, I'm sorry. No, 6 to 4. 6 to 4.
6
sorry.
to 4 out of 10.
Yeah.
Out of
Sorry.
6 to
And-
4 out of 10.
Oh,
Wait,
I'm
there's
sorry.
12
No,
of you.
no, wait. I'm sorry. I'm an accountant. I can
6
count.
to
Sorry.
6, 8 to 4.
I think it was more like 8 to 4. It was because it was leaning more towards for the respondent, definitely. But there were quite a few who initially were finding in favor of the plaintiff. But it
And
did
Judge
take.
Bev said, please don't do that. That was the first thing she said. Please don't take a straw vote.
Oh, she did? Why?
She did. That was one of
Why?
her instructions.
Why? If you've already gone through the evidence and you all
I'm
agree,
telling you,
why-
it's one of the, she wants to involve herself in the jury process. Like she would probably want to go and deliberate there with them if she could.
she wants to be in charge of it for sure. It sounds like. We just felt that was natural. Let's see where we are. Let's see how.
Okay, so
we are.
you were split down the middle. It sounds like you're about 6
Pretty
to
much,
6.
yeah.
about
We were
half-
close, something like that. I don't remember exactly, but
okay,
yeah.
and what did you do after that?
So then we just I just kind of had a group open discussion of these are the reasons why you think, so for those that think in favor of the plaintiff, give the reasons why, and then those of us that were, then we took a turn. So and then we would kind of debate each point, and talk it through, and like I said, one came down like, well, the contract says this, and I was, oh no, it really doesn't. So it took kind of that. I think it was a Thursday night, and I went home and I thought, why does she think it says that? And I was like, oh, English isn't her first language. And she came here late in life. So I was like, oh, maybe she just doesn't understand. And so I said, oh, do you understand that this comma just is clarifying? And it's not a period, it's not a separate statement. And so once that was clarified, then that person flipped to the other side, to our side. So there was things like that. I will say that the two holdouts that were, was 10 to 2, and the two holdouts were not from the United States. So I often do wonder if they were not understanding a lot of the material, what was being said a lot.
My internet
A lot of
keeps
times
crapping
attorneys
out.
back
Sorry,
and forth.
folks.
Oh.
I think too much excitement going on. We're overloaded.
Too much energy for this.
Go ahead, Lindsay.
And so, where was I? Sorry.
So what happened after you took the straw vote? You had one person who said they thought this, and then you went home and you realized, wait a minute, there might be a language barrier. They may not be understanding the contract that has been discussed. So what happened after that?
Then I went and I described just being, like I said, I got my CPA in 2001 or no 2000 whatever, And you know, I read business contracts all the time. And so knowing that, but also like, oh, the basics of really what comma placement does. It's not a period. It doesn't start a new sentence. It's really just kind of giving more information to the first part of the sentence. You're qualifying that. And once that was explained, one girl was pretty open about the fact that, oh, okay, now I get it. Okay, I understand. And, you know, and after that, we talked that through and a little bit more. And like, then we were getting closer. I think we had 2 people flip after those discussions. And so it's just kind of whittling down to like, what are you saying that I'm not? Like, you could be right that I could be, I'm not saying I'm right, but so convince me. And being open to that. But I feel like from this, I heard, I don't know if it's a rumor, but like one of the jurors was crying or something. And I just thought, is there a bully in there? And I immediately thought that the four person that Bev chose, I just had this feeling. There's no other reason why. I have no facts to back that up. It's just a feeling. And then wondering it also like you, if it's the holdout.
The crying juror, if I may interject, I believe is one of the alternates, not the one on the jury.
Okay.
What we have confirmation of is some of the faces of the jurors as they were walking out yesterday appeared frustrated and flustered. Hold on one second. Hey, babe. You said you saw the tweet. Do you mind sending it to me if you can find it, of the reporter who sent that? That one of the jurors one of the men was smiling. Who was the reporter who did that? Do you remember?
It might have been Jess Masada, but I'm gonna look.
Do you mind sending it to me? And let me know when you sent it. Thank you.
And like, because she picked him out in court, they would already know who the foreman is. So would they know it was the foreman?
Yes.
So we might have that.
The reporters would, but I don't know. We may or may not have an indication. Chandler is going to look for it.
Okay. I'd be really curious, but yeah.
Yeah, me too.
It sounds like to me, it sounds like I could see somebody being like, you're an alternate. Your opinion doesn't matter. Somebody who's a bully and just.
Well, no, if an alternates don't go in the room. No.
That's right. Did they?
The alternates are sitting outside the courtroom. I'm sorry,
Okay.
outside the deliberation room in the courtroom.
Okay. I'm forgetting that part. It's been a few years, but I thought they were in there in case something happened, but they.
No, they're there just for protection to make sure that the reporters don't try to poach them. We're losing you, Lindsay.
Oh, are they there?
No, you're having connection issues here. I'm going to remove you for just a second real quick while your connection stabilizes so that we don't. Oh, there we go. Now you're back.
Okay. I was like, come on, Elon. Come on, get that Starlink going.
Well, do you have the Neuralink or not the Neuralink? Is that Neuralink? What is it called?
Starlink. Yeah. Starlink. Yeah.
Starlink. Yes.
Yeah. Yeah.
Okay. Anyway, continue to tell us. So you continued your deliberations. What was that process like? How did that develop? How did that evolve?
And it was, even for me, like after that many days, it was getting kind of frustrating, but it kind of takes a lot to not one time like roll your eyes or, you know, why don't you agree with me? It takes a lot of restraint, but you have to keep doing that because you will respect your fellow jurors. But it took a lot to keep like, okay, let's debate each issue if we have to. And I feel like maybe I feel like maybe if there's a hung jury, they're not going through the points. Like, which point are we not agreeing on? What point is throwing you to that she's guilty? What are the facts that you see? And I don't know if that's happening in here. Because to me, you wouldn't come out and say you're a hung jury unless you've gone through every single reason why they think that this Karen would be guilty. At this point, anyway, I can't imagine that they've gone through everything. To me, they're like you said, it's on the burden's on the Commonwealth. It's not on it's not on Karen's defense counsel or her to prove her innocence. So I'm not sure. I was thinking that they're just going over every point, maybe one person at a time to like, what's your hold up? Let's talk it through. Let's get through it. Because there's been so much evidence and so much time, or maybe and it could be like I said with some of the jurors, it's just a misunderstanding. I mean, my mom was born and raised in Scotland, and like some of my uncles, when they start drinking, they're speaking English and I can't understand them. So I can't imagine in a courtroom where we had fans and it was not, their backs were turned to us a lot of time, that maybe they didn't hear things.
Yeah. Go ahead. Sorry.
Oh no, I was just saying maybe they didn't understand things that were said, or they missed this bit. So it's kind of you just going over every little piece of the information.
Maybe I can enlist chat. So Chandler's having trouble finding it. Chat, there was a reporter yesterday that reported that a man was smiling on their way out from one of the jurors. The man was smiling from their way out from court. Does anybody know who that reporter was that tweeted that? What was the name of the reporter that tweeted that information? Because I only saw a screenshot. I never actually saw the tweet itself. So maybe chat can help us out. Go ahead, Lindsay.
The way it makes me suspect. That's why I was thinking the foreman was the holdout, because I would think that the foreman would be like, okay, let's keep going. Let's try to debate each issue. And there's no way they could have gone through 6 weeks with evidence to find that issue, or maybe they just disagree on something. But there would have to be. I would say that if I were the foreperson, that what are the facts? As we said, we're deciding on facts. What are the facts that show that she's guilty? And you tell me those facts that you're seeing that we are not, and then go through those one by one with that person. And I just didn't see that, because I didn't think it was very long for them to say we're a hung jury. We're hopelessly deadlocked at this point, because I didn't think it had been very long.
Yes, there it is. That's the one. David Bienick. Yes, that's the one. I remember that name now. There it is. No. Wait, sorry. Wait a minute. Where is it? That's the screenshot that I saw. It was David Bienick. Everyone is saying they saw it and now they cannot find it. It was a screenshot. I saw a screenshot. I'm sorry, Lindsay. Please continue.
Oh, you're fine. No, you're fine. Take your time. I'm curious to know as well.
I'm listening. I'm listening to you. We're all curious about your experience, because we're trying to figure out what is going on with this jury.
Yeah.
What are they talking about? So you telling us that you are trying, you have some people with language barriers who may not understand the contract. Did you all talk about your personal experiences at all? I'm sure we're all curious to know.
Yeah.
Did you all talk about your? We found it, David Bienick. You got the tweet?
Yeah.
Send it to me. Go ahead, Lindsay.
Everyone knew what everyone did for a living, and especially after 3 weeks, what else do you have to talk about? And so, and everyone in there, I felt was a very smart person in my juror group. There were some that, at first, one lady said, when we were talking about things, and she's like, I'm just going to go with whatever Lindsay says. I trust her. And I'm like, no, you can't do that. I need your.
No, you have to come to your own. Yeah.
Yeah. I was like, yeah, just give me some facts. And really, you have to be comfortable with this decision on your own when you leave. So, so I just think that who's ever supposed to be leading the group, if they were saying, well, hey, we're deadlocked, and it's only been this many days after a 6-week trial, that's where I'm leaning to the verse of foreman of being the holdout and not being a good foreman, and maybe a little bit of a bully, sadly.
So let's put a quick pause real quick, Lindsay.
Yeah.
This is David Bienick. I was standing next to the courtroom door. So this is at 4:11 p.m. yesterday, June 27th, right as they were leaving. I was standing next to the courtroom door as jurors filed out. One man was smiling. The others looked as if they had a long day. This is very telling, okay?
Yeah, I agree.
One man smiling, meaning that's more than likely the holdout. If all the others, assuming this tweet is true and accurate, the holdout is a man. We don't know if that's the alleged former police officer or not. But it may be, but based on all the information that we are receiving, I believe they are 11-1. They are 11-1. They're 11 not guilty, 1 guilty. And this person refuses to flip their vote.
And maybe they refuse to talk to the other jurors too, if for whatever reason.
Maybe. And so, here's another question. Is this the foreperson? The one handpicked by Bev, the one not susceptible to being randomly picked as an alternate. We don't know. There's no response to that.
Okay. you know, it's hard to say what the motivations are, but I think as a juror, you want to solve this case. They've dedicated their lives for a very long time to this. They don't want it to go and not be resolved. They want it to be concluded and know they did a good job and they did their service.
Yes.
And I can't imagine. So if this guy's coming out smiling, I mean, the holdout, he's playing a game, or he's been, like he said, paid off
Maybe.
or whatever, in my opinion, or the foreman, and I can do what I want. I don't have to, or I could see him being there. I don't have to tell you why I feel this way and not
Tell us.
Yeah. And so,
I thought you were going to give us an opinion. Sorry. Go ahead.
oh no, I forgot my train of thought, but I could see that happening. Luckily I didn't have that sort of thing happen when we were deliberating, but I could see it happening with some, especially when I heard about a lot of these people in this small community. They might be that type of person or somehow connected. I don't know, but it does seem strange to me that just after that many days, I mean, it was just Wednesday and there's a ton of information coming out and saying we're deadlocked. Somebody must have a pretty strong, if it's just a one holdout, he's got to have a pretty strong personality and opinion about this and not going to budge, and everyone else is just frustrated. And if he's not willing to talk, I could see if he's not willing to talk, the judge is like, what can we do? Because otherwise I think they would just keep working through it before coming out after just 2.5 days, 3 days maybe. It didn't make sense to me. But like you said, I don't know why those instructions weren't given or why it wasn't asked. It's always asked, to my knowledge, what a split is if there's a hung jury. And I hope that they can figure it out. And I hope Bev does give the instructions that you just read to the jurors. It seems appropriate. I mean, part of those instructions I would think would be nice to have when you're going into deliberations, to be reminded, like, this is our purpose, and because you can get lost in the drama of things over time, and by the time of the trial, you're exhausted. You've been sitting in the courtroom, and you're like, unlike everyone else, they can't go home and talk about what's been going on and why they're stressed out, or why, because this is somebody's life you're taking, what's going to happen in their life in your hands. You want to make the right decision, and you can't talk about it with anybody else, and say you can't tell anybody what trial you're on. Even though I'm sure people know when someone's been gone for this length of time and they're on jury duty, I'm sure they figured it out. But you can't talk to even fellow jurors about the stresses or like what upset you today or anything else. It's pretty exhausting. You have to keep it all in.
Yeah.
So,
how did that experience make you feel as you were leading the pack?
I think I did a good job of being fair and letting everyone have a voice and no one feeling intimidated. So I felt pretty good. I just, like I said, I was, before, like when we voted, I already knew that the respondent was not liable, and I knew why. And, but so I was pretty confident. So I felt good about that, but I was also open to listening to other jurors who could have seen something I didn't. You try to pay attention for a solid, as long as you're there all day, but there's times where you're like, oh, it gets warm in there. I know they had issues with it being warm, which, makes you kind of sleepy. You're not moving around. You can't get up. It's difficult. You're sitting in a chair, everyone's watching you. It's intimidating. So that part alone is stressful. And then, so you're really trying to pay attention, but sometimes your mind drifts. So I was thinking, like, I want to hear this person. Maybe my mind drifted for a minute. I didn't hear anything. So, or hear something that was what their sticking point. So until they go through these are the facts of why. But if that person's not willing to talk, that's the only thing I can really think of would be going on. That will hold out. That person's not willing to debate is like, nope, I don't care what you guys say, and won't give the reasons why. But, I'm sure that some jurors will have a book after this for sure.
For sure.
I know. I was like, okay, let me just come up with a name. Read between the lines would be right. That would be a good one, right? So, but I'm sure that, and they're entitled to. I mean, it is a stressful process. I mean, and if you have a partner at home and you can't discuss your day with them or anything, that makes it tough, right? You can't tell anybody. You can't tell your friends, and just kind of I just need to vent about something.
You're kind of stuck in limbo. You can't talk about it until it's over.
Right. And you can't even, you're stuck in a jury room. And like I said, the only thing you really have in common with these people initially is, at first anyway, that you know of is this case, and that you can't talk about the case. And so it's really very until you go through it, and especially for such a long period of time, I don't think you can really describe it too well. I hope I'm trying to, but it's a really weird feeling that you don't realize till you're going through it. And also, like after we were done with deliberations, and they said, you know, the attorneys want to come and ask you questions. I'm like, I am out. I'm not going to be grilled, you know. But from one of the other jurors, because of course we became friends and, you know, text each other. Like, they came in, and the plaintiff is saying that you already like found in favor of the respondent because he made a comment about being an accountant. I think that's insulting to me. Like, you know, no. I
But
mean,
that was the only reason you made that decision, is because he's an accountant. That's disrespectful. I agree with you.
Yeah, I thought, as much as I was so committed, like, I don't care. I don't want to be an accountant half the time. I get it. Most people don't. And I was really offended by that. So, but I wanted to ask you, in our case, the juror names were public information and in the court records. And what was shocking to me, and thankfully the respondent was established. He was actually an attorney out of Washington, D.C. He worked for professor at Georgetown and has his own practice. That was a respondent.
12
and
angry accountants. Yeah, that's very accurate, Q.
Was that
12 angry accountants.
we're all angry all the time. Yeah, we don't ever have fun. Right? But it was shocking to me is I'm at my place of work, and this is after the trial, and suddenly there's a letter in my inbox, and it was from the respondent saying thank you.
Oh,
It was
really?
It was creepy. Yeah, I was creeped out at first, but then it was okay. But it was really creepy. Yeah. So I like that. It really like it just my mind started racing. Like, what about these people that are on trials, with criminal trials, and people are in jail? You know, I mean, I thought, well, they should just, why don't they just refer to them by the number? They don't need to put out their names. But it wasn't hard to find me. I have a semi unusual last name, and the combination with being in my profession, it wasn't hard to find me. And he wrote a letter, and it was very nice. And luckily he's on the East Coast, and I felt a very respectable person. I'm, professor at Georgetown, an attorney. He was moving his parents into, like, remodel his basements to move his parents in because their health was failing. He seemed like a really decent guy, but he was just genuinely saying, I wanted you and another person, his name is Wayne, on the trial. I just knew I wanted you to, because you would be the most reasonable. I knew you guys would be reasonable and see through the BS, basically. So, but it was creepy. So I don't know if that's how it is in all states or for all cases. I'm not sure, but I think that's pretty serious. Like, you can easily go after a juror. I mean, and I didn't realize that because they do such a good job on TV in protecting the identity of the jurors. So I was really shocked to know that our names are right there. They know what we do, where we work. So it's pretty easy to find us. And that was.
I lost you again. While we're waiting for her internet to reconnect, I want to answer some of your questions, because some of your questions are like really, really good. Oh, there she is. Okay, she's back.
So I have a real, I don't know if you know this, Larry, about like how public is juror information. I think it's a real issue, actually, after my experience. Luckily it wasn't, after the initial being kind of creeped out, it was fine. And I saw it as kind of a compliment. But imagine if it wasn't. Imagine if it was somebody who was angry. So I'm not sure. I don't know how is in Kentucky, is the juror information public? Is it listed in the court documents?
Is what stated in court documents. The
The
juror information?
Sure.
Yeah, it's all,
The
we
juror.
have this thing called the juror questionnaire that everybody fills out. They put in their
Yeah.
address, their current occupation, their date of birth, their state of residence, their county of residence, make sure that they're a proper juror for this case, if they're at least 18 years old, their spouse, their children, the occupation of themselves, the occupation of the spouse. I mean, it's very, very, very detailed, and it's very, very, very
Mhm.
private, and it has to be sent back to the court clerk. Like, you don't get a copy of it, you don't get possession of it. You have to give it back to the clerk when it is done.
So, okay.
It's very, very guarded.
I know that I didn't see any of that information in the public records because I went and looked afterwards. But I did see our names listed.
Yeah.
So that was.
Let me get to some of these questions, because some people have some very
Public
excellent questions.
Yeah.
Cunning Linguist says, Uvalde chief of police has been arrested. Okay, thank you very much for that, Cunning Linguist. I don't know what that's about, but I hope details will come to light. Amber says, if she did her job, then it would be obvious. If I'm guessing Auntie Bev did her job, it would be obvious. Maybe. Now this one, Swiss Education Information International. Can Jackson tell Bev that she has to follow that instruction? I tweeted this because I think this is very, very important. Neither David Yannetti nor Alan Jackson are interested in an Allen charge. If the jury's coming back, we can't decide. Both defense lawyers want a hung jury, because a hung jury is a victory for the defense. Okay, neither of them wants Judge Cannoni to send them back. So this is the weird part. Judge Cannoni violated the law, clearly. She did not properly instruct the jury, as we saw. There's specific instructions that she's supposed to read. And why didn't any attorney object? First of all, Lally doesn't know about it because Lally is an incompetent prick. And neither David Yannetti nor Alan Jackson, who are the competent attorneys in the room, are interested in having that Allen charge read to the jury. They want a hung jury. You heard David Yannetti. He wants to send them home. He's like, Judge, they can't decide, send them home. And so that's, I think, and I'm very, very convinced. I'm very convinced at this juncture, based on the tweets that I've been reading, the emotion of the jury as it appears. It's all hearsay, so I'm unfortunately I have to rely on it. But if they're truly 11-1, based on the information, and the one man refuses to cave, and he will not cave, he will not budge. He's like, nope, guilty or whatever. I don't care. We need to convict her. They're going to hang. 11-1 is a hang. And we're going to get to a couple more questions, actually. People were asking about it as well. So can Jackson tell her? Sure, he can, but he doesn't want to. He's not interested in it. He would much rather have a hung jury, and that's a win. Remember, anything but a guilty, a one-word verdict, anything but a one-word verdict is a win for the defense. No questions. Not even a question. 100% victory. A not guilty, a mistrial, a hung jury. That's a victory, victory, victory for the defense. A guilty, that's a loss.
Do you think they would retry if it was a hung jury?
No, no chance. Not a chance.
No.
Because Lally cannot get his witnesses to get their lies in order.
Right. They'd be worse by then.
No
right?
way.
In so
Can you
much-
imagine?
Yeah.
First of all, how many transcripts are going to be printed sitting on defense counsel's table? Previously, at a previous jury trial of this case, as you know, this is a retrial. Well, you probably can't say that. At a previous hearing of this case, you testified, blah, 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 and today you said bleedy blah. So which one is it? Are you lying today, or were you lying on June 15th, 2024? Where is the lie? Which one is the lie? I mean, these witnesses have lied so much at every turn. It's going to be completely impossible to study, memorize,
and probably
be able to testify
experts
for
are
all 70 jurors. What?
Right.
What did you say?
I was going to say they probably can you hear me? Probably too,
Yes.
the experts would be allowed to testify more than they were.
What
in
about
this
the
trial.
experts? I don't
They had
understand.
them.
The
If
experts
they
would be
retried
allowed
it.
to do what?
Like if they retried it, then the experts, especially on the defense, would be able to probably provide more information than they were in this trial, I would think, given
Why?
the circumstances, like especially the one at the end. Because
Wait, what
I
do you
think she
mean?
limited
How?
the information. Like the ones where she limited, like the dog bite expert and the two engineers. where they
Like
were
maybe
really-
addition. Yes.
Yeah.
Absolutely. More
So-
information may be able to come in, especially if we have a different judge, maybe a less biased one. Less
Right.
bought one, like if they change venue, if they change jurisdiction, tons of things could happen. Absolutely agree. Absolutely agree. J. Water Roadless Wolf asks, could the other 11 jurors request the dismissal of the one? No. They are tasked. They have a monumental task to make a decision in the Karen Reed case. There is no cherry picking here. Because another question comes, can the 11-1 choose an alternate to replace that one? No, Lisa. No, they cannot. They're the ones who have been tasked. They're the ones who've been selected. They're the ones who must decide. That's it. It's end of story. They can't take an alternate and choose to replace unless, actually, no. I was about to say maybe if one of them ends up in the hospital with, like, I don't know, gets hit by a car or something. I don't know. I'm just going to make it graphic and gruesome. If one of the jurors is unable to deliberate, then it's a hung jury. It's a mistrial. If one of the jurors is unable to deliberate, it's an automatic mistrial because 11 jurors cannot decide this case. It has to be the 12. That's it. There is no. Jay Water Roadless Wolf also says, Polly Shore, jury duty. Thank you for that. Andrea Auntie Everything says she served on 2 Massachusetts juries and we elected our 4-person. What?
Wow. Wow. I'd be curious to know the law on that for sure. That's crazy.
Oh, apparently Turtle Boy has been kicked out of the courthouse. The fake victim has just shown up with
He's so intimidating.
in the buffer zone has forced me to leave because of the bogus order she got on me for lying about an assault. I'd like to go to the buffer zone to visit Turtle Riders, but she showed up in order to make me leave. I skipped a couple of words there in his tweet.
Oh.
He's just trying to be insulting. Like I love Turtle Boy, but he needs to stop making this trial all about himself. That's the only thing. That's the only thing I'm
There
annoyed
is
by.
that.
It's all me.
And he pushes the envelope to an extreme.
The Sunday altercation was completely unnecessary. It could have been avoided if he just didn't show up at the restaurant. But again, we already rehashed that. That's a horse that's been beaten to death. We're not going to rehash it.
I missed
But
that.
I want to know from Andrea. Andrea, how on earth you served on? Babe, did you hear this? We have a person in the chat who said she served on 2 juries in Massachusetts, and they selected their own 4-person.
What? No.
Yeah.
Okay, that's weird. That's really weird. That's suspicious.
Yeah.
So maybe it is. Maybe the judge can decide in that state.
What on earth?
And if that's the case, just another issue, that another fact that she's on the team of the Commonwealth and the McCabe's. I had read something somewhere. It was somebody not from, it wasn't from a news source or anything, but somebody had made it, I think it was in a comment section, that Beverly rented her place, was it in Martha's Vineyard or something, to the McCabe's at one point, rented her vacation home. So
this whole case is uniting the nation. I love this.
Yeah,
I swear, everyone and their mother has that spinning fan. Somebody even tweeted this meme right here. Let me show you. Let me show you guys. I had to share it because it's hilarious. How long till I have to stop looking at this? Isn't that just brilliant?
that's hilarious.
How long till I have to stop looking at this spinning fan on my phone? Everybody's phone also looks like this. Let me show you this one. It's great. Hold on. No, this is not the original. It's the NBC 10. It's the original. There we go. So everyone's phone looks like this.
right?
With
Honestly.
the little spinning fan in the corner because they got the video. Especially if you have an Android, you can have multiple tabs open. If you have an iPhone, you probably can't. But yeah,
Right.
you just basically have the spinning fan in the corner. It moves, right? I can move it. I
Oh,
can move
sweet.
it. I can
That's
close it. It's a video. It's a video. You can just like move it around. I can if I drag it all the way down, it will close it. But if you don't want to
I
close it, you can
feel
just
you're
have
gonna
it.
miss that, man,
You
Larry.
can have it in the background.
Yeah, I want to like screen record it so you can have it for later. You're gonna miss that, man. I have a
No,
feeling.
pass. Hashtag pass. Hardcore pass. Let's see what else people are saying. So yeah, Andrea, I'm interested. Like if you're still in
Yeah.
the chat, I want to know more.
Yeah. So was she on a jury? Can she
Two of
provide?
them.
Yes.
Two of
Oh,
them.
okay. Wow, that's incredible.
Rebecca Welty says the Murdoch foreperson was chosen by the judge. Also, one juror was the brother-in-law to a witness, which was that's. I mean, it's a small town. Everybody knows
Yeah.
everybody. Brutally Lauren says, can you tell us about the paper Alan Jackson argued yesterday? You mean Wednesday? There were no
Oh, you mean
arguments yesterday.
Juror instructions? Is that what she's talking about?
No. Oh, yes. Not the jury instructions, but yeah, the jury instructions. Sorry, the jury verdict form. That's specifically
Yeah,
the instructions,
sorry, yeah,
the jury
yeah,
verdict form.
Mhm.
I tweeted about it, and if you missed it, or if you want me to just kind of, so basically, it was about this right here. Let me show you all. That was on Wednesday. That wasn't yesterday. That was on June 26th in the morning. I wrote, Auntie Bev lied. There's a distinct difference between the way the forms are supposed to look and the way that they look in this case. So this is the way the form is supposed to look. We, the jury, unanimously return the following verdict. We find the defendant not guilty of the offense charged or any lesser included offense. Or we find him guilty as charged, lesser offense 1, lesser offense 2. This is how the jury instructions are in the Karen Reed case. In the above entitled case, we, the jury, find the defendant is not guilty. Guilty, guilty, lesser, guilty, lesser. And by the way, lesser misspelled, lessor. And why is this capitalized? I have no idea. And this is not capitalized. I have no idea. It's very, very poorly written. And Alan Jackson actually stated to Judge Bev, he said, Judge, we had a discussion about this yesterday. And she said, well, I said I was going to take it under consideration. I didn't say I was going to actually change it. And he's like, what the actual F, Judge?
Right.
Like, we talked about this. So they're supposed to say, if we find the defendant not guilty of the offense charged or any lesser included offenses. And the verdict form in the Karen Reed case simply reads, not guilty. And this is what Jackson was talking about. I 100% agree with him, and Auntie Bev changed it on Wednesday. On the second day of deliberations, again, an unprecedented move. I have never in my entire 11 years of practicing law on this planet or any time before that, have I ever heard of jury instructions being modified in the middle of the jury's deliberations. That has never happened before. There are so many firsts in this case. It's disgusting. It's despicable. It is, I'm without words. I'm without words. James Brostrom, I hope I'm pronouncing that correctly. Would a mistrial hanged jury be a win for the McAlberts? No.
Yeah.
No, they need a conviction. They need a conviction because if they don't, if she's convicted, if 12 men and women decide she's guilty, they win because now they're skating by. They're scot-free, at least for the time being. Maybe not forever, but for the most part, if Karen Reed is convicted, then it means 12 people independently, unanimously agreed that obviously there's enough evidence here for a conviction. But anything but a guilty verdict is a loss for the McAlberts because if it's a hung jury, that means they can't decide. There may be a holdout. There may be, corruption afoot. There may be some misdeeds afoot. Something smells rotten. Maybe truly they can't decide. It could be anything, unless and until they do interviews. Like remember the 3 jurors in the Alec Murdoch case? I don't know if you followed that case. There were 3 jurors. There were 3 jurors in that case that did an interview with NBC. I think NBC. They did an interview, and there were 3 of them, and they did an interview, and that was a mess. That was a mess. And then oh my God, it takes me back. And then what's her name? Becky Hill wrote a book, and then she was put on the pedestal, and then they did a questioning of the jurors in open court, something I've never seen before in my entire life.
Right?
But anyway, let's not go there. It's a whole can of worms I don't want to open right
Wow.
now. Would
I
that
thought
provide
what
plausible? Would
Like,
that provide plausible deniability for their culpability with the federal investigation? So, would a mistrial or a hung jury provide plausible deniability for their culpability? No, no, not at all. Absolutely not. They're still on the hook. They're still on the meat hook. They're still liable. They're still culpable. Could that be the reason for the plan? Well, look, you gotta do something. If you're certain that you're going to lose, a hung jury is better than a not guilty for the McAlberts. That's for certain. A not guilty crucifies them from here to high heaven. But a hung jury means, well, there's at least one, and their claws run deep, the claws of corruption. So
Mhm.
a hung jury is my favorite kind of unhung hero. I swear to God. A Willie 35 says, if retried, could Karen use public defender since AJ did all the work?
I mean, I'm sure that.
Why? No, God, no. Oh, absolutely not.
Yeah.
No, it's not about Alan Jackson did all the work. If Alan Jackson's gone, you can't emulate, you can't copy Alan Jackson. Alan Jackson is one of a kind. Yeah, Courthouse Becky got bought in trappings of fame. Yes, she did. Yes, she did. Okay, sorry. What were you going to say, Lindsay?
I'm not sure now. Sorry.
I was trying to get through these.
Yeah.
Do you remember what you were going to say?
Oh, sorry. No, I'm like, no, I forgot. Sorry. I thought you were going to read another question. Sorry. So I was waiting on that. Sorry.
No, we're all caught up. We're all caught up.
Okay.
So what else can you tell us? We're listening.
So
From your jury experience and how that felt and how much pressure or lack thereof that you had.
I can say afterwards, it was really a weird feeling too, to like not, you're with these people constantly and then suddenly you're, just back to normal life. And then still like, for me, even though I was very confident and, that in not the person not being liable, you're still like questioning, did I miss anything? Because you don't want to mess with somebody's life. It was a significant amount of money. And so, but I know, even though I was very, very confident in what I was saying, I thought, what if I missed something? Or what if I didn't, and going back, but you have to let it go. But sometimes it's really hard to let that go. Also, one thing, this is just like a petty, and maybe, I don't know about you, but for me, every time that when I was a juror, we came in the courtroom, the judge was already there. And so when we came in, like the judge would stand for us and then as everyone else in the courtroom. And I found that like Bev coming in after the jurors, there was just a little bit of a kind of a petty little high horse thing, kind of less respectful to the jurors, I thought. And so they stood for her. Or in my case, the judge was I felt very appreciated and grateful that we were there, and a lot of respect towards us. So I think she has been respectful towards the jurors, to my knowledge, that from what I've seen. I haven't seen the entire case. I've seen most of it, but I haven't seen anything that was overtly disrespectful. I think she's very, soft with her words when she's speaking directly to them, and speaks with a smile and tries to not be intimidating. But I don't know how they really feel about her overall. There might have been other interactions, but you definitely don't want, as a juror, for the judge to be intimidating to you. That's definitely something you don't want. I mean, you have to follow the rules, but you want there to be a respect. So that's a petty issue, very petty, but I did notice that every time. And I did think too that I didn't even feel like Beverly and the attorneys even tried to like resolve issues before the court got started. Or it's like in my case, they would stay later after we left. Maybe they would excuse us early, and then they would go over the evidence that was being questioned or for the next day to make sure they're all on the same page. So that way we weren't just sitting there idle waiting on them during the day. So like, we knew that they were there late. We knew that they worked through lunch sometimes to try and get stuff resolved. So we weren't sitting around. And I didn't feel like that was, I don't think that jurors were really considered in this case for the further time. It's already been 6 weeks. It's a long time. And I just felt like there's a little bit of lack of respect on that part. I think they could have done a lot of resolution, and maybe that just doesn't happen in Massachusetts. I don't know if you know, Larry, if that's common for an attempt to work it out with a judge ahead of time if there is issues. I don't know what your experience is, but at least in my case, they did try to resolve a lot of issues in the evenings or through lunch. They try to get a lot done. So
The jurors?
no, so they would excuse the jurors maybe earlier for the day if there were issues like with the evidence being submitted or the questioning or whatever.
Oh,
So they would try to work it out when the jurors weren't there, so they didn't kind of waste our time with us just sitting there idly and being dismissed again and waiting in a room until they call us. So maybe they'd like, okay, you guys go home. We're going to work through all this. We're going to stay late and go through all of this, so there's no issues tomorrow. So like before court, so after court ended or before court started or during lunch, they really did try to go through those issues ahead of time, so they weren't wasting our time. And I don't feel like I saw that in this trial. And I didn't see a willingness from Bev to try and to work through those issues. It was like she was done at 4, she's out. There could have been more, but I would think that there would have been some discussion about them going over stuff after court ended if that were to be happening. And we saw that attorneys leave every night, so I'm pretty sure that it wasn't happening. So I felt that was disrespectful. They could have gone over stuff before, let the jurors go home. You guys discuss and figure it out, and we'll come back tomorrow. That would have been a nice way to handle a lot of the situations. So I thought it was a little bit disrespectful on that count too. This is a long time, like I said, out of these people's normal everyday lives. They have lives to get back to. So
Bev was very what do you call it? Controlling? Is that a good
Yes.
word?
Mhm. Yeah.
Did you get that feeling too?
I did. And I did also, like I said, she's like kind of on her high horse, even with the jurors. And I don't think that's appropriate.
Tell us about that. Why do you feel that?
I guess just because of my experience and her lack of, like I said, even just coming into the courtroom, she always came in after the jurors. So the jurors had to stand for her. Whereas in my case, the judge was already there and she stood for us when we walked in.
Really?
Yeah.
Okay, so that's very common.
So it's very common to do what Bev did, or
no. What you're saying, that's way more common than what Bev did.
And so to me, it just kind of was like just another small check mark to why I didn't prefer her. Let's just say, I think she was that great of a judge. Just little things like that.
There's a reason her nicknames are like Auntie Bev, Benzo Bev. They're just very. There's no respect for this woman. There's no honest, and people don't see her as a judge. No. They see her as just
an annoyance.
Somewhat
an annoyance.
Annoyance, yeah.
Yeah. And I don't know if you noticed, every time she'd be just sitting in her chair and she'd be like swinging in her chair back and forth like a 5-year-old would be. I was like, somebody's testifying and she's going back, swinging back and forth in her chair, or like twirling her glasses. And I thought, really? You're the judge. You're supposed to lead this. I mean, I didn't see any. Even jurors don't swing in their chairs, to my knowledge. I mean, we didn't. It just seems disrespectful. And so it just seemed like she was either bored or whatever. I can't believe I have to be here. Oh my God. That's the attitude I kind of got from her a lot of times. And maybe I'm just being overtly picky. I don't know if anybody else felt that way, but yeah, just the simple fact, the biggest factor being already being in there. I felt like she should have been, at her podium already before the jurors came in. And maybe they would resolve some issues right there before the jurors came in, or come in early and go over issues. So wasting jurors' time. So I don't know. But I've only had the one real experience in court like that. So you can tell me what's normal and what's not. But I know mine's not going to be the same as others, of course.
Sure.
So.
No. But for the most part, listen, first of all, thank you for coming on. Honestly,
of course,
you are giving us insight that only exists in the jury room. And you had a chance to experience that. You sat in a jury room with jurors deciding a case for 4 days after 3 weeks of testimony.
Yeah.
You sat there and you listened to one another, you talked it out, you grinded, You tried to come to a decision. You didn't need unanimity because it was a civil case. But look, we'll take what we can get. I'll be honest with you. At this point, we are all very, very hungry. When you told me last night that you're actually were a former juror and we've known each other for a couple of years now, I'm like, are you kidding me? Like, do you want to come on? My audience will love you. I don't think, chat right now, tell me, do you care that she was in a different jurisdiction and that she was on a civil case and this is not Massachusetts and this is not a criminal case? Do you honestly care? I don't. I'm eating this up. I know I may seem distracted because I'm doing a few things at the same time, trying to keep tabs on a few things, but I'm listening very intently because to me, this is fascinating. I've never been on a jury. I've never been selected. I've never been chosen to even come in. I will, as a lawyer, it's absolutely possible. You know, we get my lawyer friends sometimes get chosen to come in, but I am in awe and I'm absolutely thankful for you to coming on and talking to us. So, is there anything else you want to tell us before we part ways?
I mean, I'm sad because when we were messaging last night, I was really wanting to just put everyone at ease. Like, it's okay, they're just going through everything. But then that happened right before I came on, and it kind of threw me.
Right before you came on, it was all shot to pieces. Yeah.
And so I was just trying to process it and come up with what might be happening. And if that guy walked out smiling, that's just arrogant and kind of cocky anyway. I just, you know, you remain professional till you get in your car. No one can see you. So especially in a case like this, that's just part of the deal. And even if it's not expressly stated, you do keep, just as they want the defendant to not have a lot of facial expressions or emotions that are visible. The same with the jurors. You try to keep a poker face as much as you can. And I felt like that was, until I got to my car, I was really trying to maintain that poker face and keep it professional, no matter what I was feeling. So for him to come out smiling, I think is pretty arrogant. And I can imagine the other jurors they're probably very frustrated. They've dedicated so much of their life and their time, and they took this seriously. And if they have one holdout, it's just kind of being a jerk. It's kind of the impression I'm getting. That would be really, really frustrating. And I could see why they would be really frustrated with that overall. They really, like, if you spend that much time on something and in the end, it doesn't feel like it got resolved, that's disappointing. And especially when you took it seriously and you did it. So I have a new take. I would love to know who the holdout is, like you said, at this point. But hopefully he's not the foreman, and hopefully the foreman gets his footing and figures out how to really talk to people and figure out where are we differing on and what's causing you to think this way.
Right. Well, I wish we could pick their brains, because here's the thing.
Yeah.
We can. That's the thing. We can.
Yeah.
I will tell you about my one hung jury experience. Okay. I've tried almost 50 cases.
Yeah.
Either first chair or second chair. And this case was in LaRue County, Kentucky. It was a jury of 6. It was a refusal case. It was a DUI. I talked to the jurors afterwards, and they told me I was winning. It was going to be 6-0, not guilty. However, in closing arguments, the prosecutor made some improper statements. I actually have a clip of it. He says, quote, "The best DUI lawyer money can buy did not do this, didn't do that, didn't do this, didn't do that." And I'm sitting there going, did he just call me the best DUI lawyer money can buy?
Right.
Like, I feel like pat on the back.
I'm glad that you saw the compliment first and not the criticism.
And then
So-
he disparaged me. He said, I didn't have a burden. I should have objected. I was just so blindsided. I was like, is he loving me? Like, what is he doing here? Like, how do I object to this? Like, no, Your Honor, I'm not the best DUI lawyer money can buy.
And is that even appropriate to mention?
Yes, it's completely inappropriate. And then he started disparaging that I should have brought in an expert. I should have brought in the medical report. He didn't bring this. He didn't bring that.
Mhm.
I don't have a burden. That's the thing. I don't have a burden. I made that mistake once. I'll never make it again. I ended up winning the case. Let me just fast forward real quick. I ended up winning the case. The prosecutor ended up, he's like, I'll bring you the medical records, man. And I did. And I showed them to him after the client fought with me for like 6 months. It was stupid. It was absolutely stupid why he didn't provide the documents to me sooner. But whatever, I provided them to the prosecutor, and the prosecutor ended up dismissing the case. So I ended up winning after the fact. But the day of, the jury apparently was split after they deliberated for a few hours. It was a short case. It was a 1-day trial. Maybe they deliberated for like, I don't know, a couple hours, 3 hours. And they came back, and the judge just looked at him and asked, how split are you? He just asked them, point blank, how split are you? This is Kentucky. How split are you? And they said, we're split 3-3. And the judge looked at me and looked at the prosecutor and was like, and I was like, yeah. And he's like, look, they're split right down the middle. I'm inclined to release them if they can't decide. And I was like, you know, and the prosecutor was like, I don't know. And so the judge let them go. And I asked, you know, judge, is it okay if I talk to them afterwards? And the judge was like, I don't care, go ahead. And I spoke to them, and it was really funny because the judge said, you don't have to stay if you don't want to. You can leave. You're more than welcome to leave. And the jurors were just like, okay. 3 of them stayed behind. Can you guess which 3?
The ones in your favor.
The ones in my favor.
Yeah.
All the other 3 were like, we're dipping out of here. Bye-bye. And I asked them, I was like, why did those 3 vote guilty? And they were like, we're going to vote guilty. And they're like, because you didn't provide the evidence. And I'm like, oh my God, the fucking prosecutor flipped the script. He put the burden on the defense. The defense didn't do X, Y, Z. And then the jurors were like, oh, I was going to vote not guilty, but he's right. The defense didn't do X, Y, Z. I learned. This was a case earlier in my career. This was like maybe 2019, 2020. I can't remember.
Yeah.
So I was still kind of like, I wasn't a baby lawyer by any stretch of the imagination. But I've never had like a prosecutor disparage me like that. Kyle Williamson, I'll never forget him. And I give him full credit. He's still my favorite lawyer to try a case against. I've never won against him. I've tried 2 cases against him. I got a hung jury and a guilty verdict, no jail time. I've never won against him yet. He's a very formidable opponent. He's the kind of lawyer I learned how to become a better lawyer from.
Aww.
So but he's slimy, like most prosecutors. He's slimy and he's a dick, and I love him for it. Because he teaches me how to be a better criminal defense attorney. So yes, by every stretch of the imagination, Auntie Bev has every opportunity to ask this jury, how split are you? Are you 11-1? Are you 10-2? Are you 6-6? And if they are like 11-1, you look them in the eye, the one,
right,
and you say, well, since you're in the minority, this is her job. This she needs to do. But she doesn't want to do it because she's bought, bait, and sold for by the McAlberts. And she probably knows if they're 11-1, it's probably 11 not guilty, 1 guilty. And now she has to convince the 1 guilty to flip. She doesn't want to do that. She's not interested in an acquittal. She wants either a hung jury or a conviction. And if she can't get a conviction, the second best option is a hung jury. So, Larry, you need to look at the live chat on Law and Crime. Why? What's happening on Law and Crime? Let's see. What's happening on Law and Crime? I don't see anything. I don't see anything interesting.
That's probably a tactic to get us to go. Is Law and Crime somebody else's somebody else's chat or YouTube channel? Is that what it is?
I don't see anything. Verdict clock passes 18 hours. No, I don't see anything.
Does anyone else in the chat? Anything? Something that we're missing?
People are saying there's nothing there.
Okay.
People are saying, I love Lindsay. Please have her on more often. She's amazing.
Okay, I would be happy to. I love you guys too. Larry does have an amazing group, and he has since day 1. So yeah,
Thank
he does.
you.
Because it's you, right? Yeah, and he's pretty awesome. Thank you guys.
Florida JD here, not too familiar with Massachusetts law. Looked up, and 5 minutes of research indicates grand juries elect a foreperson, but in criminal trials they are randomly selected. Oh, there you go, Florida Dad. A High Ground Cantina says 234A and 68A. The court can choose the foreperson, but after the jury's been impaneled and sworn in, I think Bev skipped a step. After the jury has been impaneled and sworn in, but the jury has been impaneled and sworn in, and then the court can choose. Maybe it's an option. Maybe it's an option. Oh, Florida, that's a disregard. I'm wrong. Wade got it. Wade? I don't know. I don't know where Wade's comment is. But okay. Thank you, Florida, for the correction. And yeah,
Aw.
she's amazing. So jury is an hour 19 of deliberations according to Law and Crime. According to Court TV, we're past hour 18, so I guess it's all the same. Well, Lindsay, I guess this is it.
Okay. Well, yeah, thank you for having me, and let me share my experience. And if you guys have any other more questions, I'm happy to come on, or if you just want to.
Yeah, let's open the floor up. I have a few minutes. Let's open the floor. If anybody has questions for Lindsay, super chat, ask her, or don't super chat. Either one is fine if I can catch it. Super chats are obviously easier because they get blocked off and sent to a separate folder. But what questions do you have for Lindsay, who's served on a jury before? 4 days of deliberation after a 3-week trial, civil case, wrongful termination in Washington State. Different rules, different jurisdiction, but the same applies. The same rules of deliberation. You get into a room and you start talking about anything and everything, whether related to the case or not. Sometimes, as we all know.
And even after 3 weeks, sorry to interrupt, but even after 3 weeks, we kind of like forgot what happened at the beginning of the trial. So 6 weeks, I can't imagine. Like they're probably, oh yeah, that happened, and that. What about that? So there's that too. But if the rumor is true, where there's just one holdout, that just throws my theory off, and I feel bad. I was here to ease everyone's worries, not create more. Sorry.
Is she a former juror on this case? No.
Sorry. No.
That's an easy answer.
If I was, I wouldn't be able to discuss it till the trial was over.
Yeah, I wouldn't have her on. I'm not going to violate some. It's not really a rule. Like some people were asking in the chat, they're like, "Is this legal? Like, is he allowed to bring on a former juror?" First of all, if I'm doing it, then yes, it's okay. It's allowed because I know the law. So you don't have to question.
Yeah.
But I mean, it would be bad form. It would be really, really, because there's two kinds of rules. There's rules of law and then there's rules of ethics and morality. Right. And I like to try and abide by both of them. So if a rule of law says this is not permitted, I would never do it. If a rule of law says, pick or choose your poison, then you look at the rules of morality and ethics. Is it, within the realm of possibility that it's not going to hurt the case or blah, 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 to have a former juror on while the jury is deliberating? I think that would hurt the case tremendously. And I would not do it because that seems unreasonable. That seems silly.
I still think they're prevented from talking until the case is over, though, even if they're dismissed, aren't they?
What do you mean?
If a juror is dismissed, and then I think they're prevented about talking about the case until the trials. They're still kind of sworn in. I'm not sure.
Wait, hold on. If they're done deliberate, or you're talking about the alternates?
Or yeah.
No, the alternates are done. The alternates can go home. The alternate, home. I should say that. The alternates should have been released to go home. They're not. They're being held captive by Judge Bev while the others are deliberating, to prevent, vultures like the media, Turtle Boy, from like getting their hands on them. And the problem is that we, as a society, we don't want to interfere with the process. Now, is interviewing them problematic? It's a flip of a coin. And if it's a flip of a coin, I probably wouldn't touch it with a 10-foot pole. Now, after the verdict is in, it's fair game. Anybody and everybody can. And I hope Turtle Boy does get like an exclusive or something. I don't care. I don't care if I get it or if I don't get it or if he gets it or someone else gets it. NBC, ABC, CBS, Fox News, Ted Daniel. Who cares? Nobody's fine too. If they don't want to talk to anybody, they just want to go home. They're tired after 10 weeks of nonsense. You know. So anyway, any other questions for Lindsay before we let her go? Peter says, what were your feelings of Lally during this trial?
Mine? Oh,
If you watched it.
terrible. I first of all, I was amazed that it was just Lally. He didn't have a team for such a long trial and so much evidence. But I thought he was he was ridiculously slow, and he kept reviewing the same things and asking questions like, "Do you know how your iPhone works?" Come on, yeah, jurors aren't idiots. That's kind of insulting at times, I thought, to the jurors. Like, I'm pretty sure they know
Like
how
Jennifer
to...
McCabe, or no, Allie McCabe. Allie McCabe was like, "Oh, I don't even know how to delete stuff off my phone."
Yeah, and maybe that's why he thought the jurors wouldn't. I don't know, but come on, don't insult the jurors' intelligence. They know how to operate an iPhone. But then you would like keep reviewing the same videos over and over again, and it just was, after you've seen it once, you know, and you can refer to it, but I don't need to see it again. I'm going to remember. Or maybe you point to one thing in the video, I don't know, but you don't replay it over and over again, and don't go over the same test. Just come on, we know how an iPhone works. It was pretty ridiculous too. And it wasn't like when Jackson was like, you have to do a couple swipes to open up your phone and make a call. It wasn't like that. It was literally like just really basic, I'm teaching my 4-year-old how to use a phone type thing. And I thought that was really insulting. And he went really slow with his, and then it took a turn where it was the defense team to go. I thought he was very short. I thought he was disrespectful to the witnesses. And I can tell you from a juror, like when it gets hostile like that, it doesn't feel good. And so I don't know why any attorney would act that way. It makes you go like feel bad for who's ever testifying. It doesn't help you if you're being rude to the if he's, I mean, obviously Jackson got heated, but it was for a reason. I didn't feel any of that weirdness, but like when Lally was rude to the dog bite expert, I thought he was short and kind of zenning at times. And as well as the engineer daddies, as people are calling him. And I just thought that's ridiculous and insulting. And it just makes it uncomfortable. It doesn't do anything for him personally. And I was gonna ask you, like, he messed up some facts in closing. Like, what happens then? Like, that wasn't what you said during the trial. I can't remember what it was. Did he like change the time or something on something? I don't know if you recall, but it was like, can they just throw out whatever they want to say that wasn't brought up in a trial in closing? Is that what's allowed? Or do you know? I don't know. Is Massachusetts different? I don't know. But or
If
can they just
Massachusetts is different, I'm sorry, I missed the question.
Oh, so like in a closing, I noticed that Lally was like, I think he had misquoted or misstated.
Oh, the evidence? Yeah. No, that's not allowed. No, that's never allowed.
So I don't know why was it allowed in this case? Now
It wasn't. It just happened. Nobody objected. It's just facts of life. You move on.
Yeah, and
Keep
I
on
thought,
living.
yeah, I just thought as a juror, I'd be like, well, you said this earlier, and now you're saying this at the end. And so like he just came out as not credible either. And also I felt there's a lot of times where he just didn't want to be there. And it probably he's one guy doing it all, so he's probably just overwhelmed and exhausted. But it kind of came off as like, I have to be here. Okay, can I talk any slower? And it was really ridiculous. And the objections from him were pretty ridiculous too, in my opinion. Just come on. And the things that he, like when he was questioning the background and experience and knowledge of the expert witnesses compared to his witnesses, I was just losing my mind thinking, you're gonna question these guys? Really? And I think a juror would feel that way too, that they would be like, okay, yeah, you're juror, like can't remember anything and doesn't know how to apparently work a phone. And
that was insane. That was ridiculous.
Yeah.
To this moment, I cannot believe Allie McCabe. I was in the courtroom when that happened, when she cried. I was in the courtroom. I was physically present. And I can tell you, the jury didn't buy it. Her crocodile tears reminded me way too much of Amber Heard. It was way too much reminiscent of someone who's just trying to manipulate somebody else using like what I think really happened is in her mind, she realized she screwed up because she said something about a man going into the house talking about John O'Keefe. and she
Yeah.
was like terrified, like, oh my God, I'm never gonna,
Oh.
my mother, Jennifer McCabe, is never gonna let me live this down. I'm gonna catch her wrath for as long as I live. For the next few
Yeah.
weeks, it's gonna be a nightmare and terror, and I screwed this case up, and if we're gonna lose because of me, like, it's over. My life is over. My mom will never be able to let me live it down. And so, you know what? I empathize with her, but I have absolutely zero sympathy for her.
Right. And Jennifer McCabe does seem like a type of mom that would do that to her child, sadly.
Yes.
She did come across that way to me. You know, most people are instinct is to protect your child, but I didn't see that from her at all.
No, absolutely not.
So, yeah. Lally, though, no, forget him. I don't know why he was picked. I don't even know why. I
Because
guess
he's incompetent. They wanted an incompetent prosecutor for an incompetent case with no evidence. Because if you select a really good prosecutor, they're going to be like, "What is this horse shit? I can't do anything with this."
got it. That
Think
makes
about
sense
it.
to me. Thank you. I wasn't connecting.
I
those
thought he
dots.
was going to get, when I first saw this case, I thought the prosecutor is going to get fired when this is all over. No. He's going to get promoted because the corruption, he's now part of the corruption circle. He's protecting the McAlberts. He's
Oh.
helping perpetuate this fake theory that it wasn't them who did it. And so now he's on the in club. He's now part of the crew, part of the ship. You've seen Pirates of the Caribbean, right? Part of the ship, part of the crew. And now that he's part of the ship, part of the crew, he's now also going to be protected, and his life is pretty much set unless and until these people end up behind bars, and then his protection goes out the window, and now he's just going to be laughed at from every courtroom he's ever going to step foot in. So
Which I have faith that sorry to interrupt again, but I have faith that the FBI is still doing their work. They always do it quietly.
I'm pretty certain they are. Yeah.
Yeah. I don't think they're letting this go. And I even think that two things can be true where she could be found guilty and the FBI could still be like, there's still corruption. We see this, this, and this. I don't think they're going to let it go just because if she was found guilty. I don't think.
Yes.
Not that I see that happening. I think like hung a jury or not guilty at this point would be, it's not going to be guilty. I think we can be assured with that it's not going to be guilty.
I'm pretty certain as well. Yes. Here's another question for Lindsay. Are you still friends with the other jurors?
I would text occasionally, actually. There's a couple that, yeah, we did. There was another guy who he was a COO of a company, and we just same as our background, so we kept in contact. He was the other guy that the respondent wanted on the trial. I think he wrote him a letter too. And then yeah, there were a few. There's a couple, yeah, that we became friends, yeah. So they don't call me mom anymore. They call me mom while I was in there. But, so we're just worried, you know. Is there enough water? It's warm in there. Did you eat? Did you go outside? Yeah. So, you know.
Lee McKinney says, can and do the jurors get paid for interviews after the trial is over? Can the jurors get paid? Absolutely. Anybody can offer them money to come on and do an interview and talk about the case in like XYZ station or whatever. Or they can choose to do it for free if they just feel like it, or any combination of those two. So it's not uncommon at all. Remember, like Amber Heard after the trial, she was obviously the defendant, but she gave paid interviews after the Johnny Depp trial was over. The only people who did not want to do interviews were the jurors in that case because they suffered enough and they were done. Melinda Damon, thank you so much for the super sticker. Okay, folks, here we are. We're almost at the 2-hour mark. I'm going to call it here. I wanted to thank every single one of you for coming on and joining us in this live stream. I hope you all enjoyed it. I hope you all learned something. There's 10,000 people watching.
Oh my gosh. Oh my gosh.
10,000 people here. That's insane.
Okay, no more questions for sure. We got them all.
We got them all. We appreciate you. And thank you for being here. Thank you for coming on.
Absolutely.
Thank you for letting me know that you're a former juror. Maybe we'll do this again sometime. And
definitely.
yeah, I think that this is going to be an experience for us all. And we will see you guys when the verdict is in.
Yeah, sounds good. Okay, bye guys.
Bye, everybody. Is it not ending? Why is it still going?